burden of proof, a lighter burden of proof. You can win a civil case, take someone's home, take their business, by proving by a mere preponderance of the evidence that you're right. There's another burden of proof called clear and convincing evidence, which is used in certain civil processes. I mean, you can take a child away from a mother's custody by clear and convincing evidence, but you aren't supposed to be able to convict someone of a crime by either preponderance of the evidence or clear and convincing evidence. It must be proof beyond a reasonable doubt. Now, you're talking about regulatory offenses, I believe.
Right. Well, I'm sorry to interrupt. Just the fact that it seems to me that the essential reason for proof beyond a reasonable doubt should be for deprivation, for a more serious deprivation than money or property. It should be for loss of liberty. But yet, it seems to me that there are certain penal offenses where the punishment is imprisonment. It's a substantial fine. It's forfeiture. Where you are, where the burden is proof beyond a reasonable doubt. And
there are
doesn't seem to be consistent.
Well, you can take someone's property, you can take their business away, you can take their house away, you can take away their child in the civil system, civil process, with a lower standard of proof than it would take to convict someone of drunk driving or public nuisance or any other number of sort of lesser types of crimes. But again, the system is that you don't convict someone of a crime unless it's proven beyond a reasonable doubt. Now, we have, as you know, because you do regulatory work in the administrative process, we have what are called quasi-criminal types of statutes where you can take away a doctor's license or a lawyer's license.
Right, and I've always felt the argument should be that in those types of proceedings, they should, too, be entitled to proof beyond a reasonable doubt. Yeah, I
think I agree with you because the loss of a professional license can be far more damaging to someone than being deemed to have committed a misdemeanor for disturbing the peace, that kind of thing. Exactly. So I know exactly what you're saying, but I think the fundamental premise I just outlined is supposed to be the way our country works. Yes, there are fines and forfeitures and penalties that can be far more damaging to someone than, we'll put you on summary probation for reckless driving or whatever. I agree with you.
Yeah, I think there was I don't think the Supreme Court, to my knowledge, has. I think there was a case, Kansas versus Hendricks. I think where there was some dispute over what makes an offense a civil, where you can put someone away because they represent, for civil purposes, you could put them in detention. You could have a civil proceeding concluding that they are a threat to society for civil purposes, for preventative purposes, and that only requires proof, a preponderance, but not guilt, not proof beyond a reasonable doubt. I think the Supreme Court has had trouble distinguishing that, and I'd love to just try to get some more clarification on the line between the two of them. When the proof beyond a reasonable doubt should apply, even though imprisonment is not the offense, is not the penalty.
Yeah. No, I agree with you. There are a lot of anomalies. I mean, look, I've often wondered, since we place more value on the loss of freedom or reputation, why can't you take depositions in criminal cases? You're allowed to take them in civil cases, put people under oath and get their statements before trial. You can't do it in criminal cases where the stakes are higher and the burden of proof is higher. That doesn't make sense.
Thank you so much for all you do, and thank you, Jordan, and congratulations for a great 300th show. I can't think of a more terrific guest to have than Tom Mesereau. And thank you, Jordan, also for what you do for us lawyers and paralegals, having great legal luminaries on every couple of weeks or so, almost every week. You're just doing a great service, and we appreciate your show. I try to let all my fellow lawyers and paralegals know about it here in New York.
Well, thank you very much.
Thank you for your kind remarks.
Thank you, Glenn.
Absolutely, and I have a few more questions for the chat, and I just want to ask you a couple other things. Tom, you had mentioned Ann Bremner, the lawyer based out of Seattle. She was doing something in litigation, and she brought up the Michael Jackson case. Can you talk about that a little bit?
Well, I was told this. I wasn't at the conference, but there's a bar association, a national bar association I belong to called Litigation Council of America. And each year they give out an award that's named after me. It's called the Mesereau Cup to a person they think has made contributions to criminal law. I'm very flattered that they would do that. And no, I was told that she spoke at one of their seminars and was very complimentary of my defense of the Michael Jackson case. She's a brilliant lawyer herself and a great legal analyst, very, very smart, perceptive. And if she complimented me, I'm very flattered by it because she's a very bright woman and a very accomplished woman and a terrific lawyer.
No question. Now, you were saying like a year ago when Jodi Arias was going for the death penalty, you thought that Kirk Nermy and the attorneys for Jodi Arias did a good job. Is that accurate, A? And if so, can you explain?
Yes, because I thought it was a very tough case for the defense. It was a brutal murder of an innocent young man who just seemed to be well-liked and seemed to be simply, having fun, and brutal killing by someone who clearly planned the crime, committed this brutal, brutal crime, and then tried to cover it up and then tried to lie her way out of it. The defense lawyers to beat the death penalty in that case was a remarkable achievement. And they did. They did. So my hat's off to them. I mean, compare that to the Scott Peterson case where you had someone, they couldn't prove the time of death, the cause of death, or the place of death. You had someone without a criminal record, and he got the death penalty. I mean, Jodi Arias didn't get the death penalty. What's her name in Florida was acquitted.
Casey Anthony.
You've had a lot of these terrorists who were convicted in federal court who didn't get the death penalty, but in the middle of all of this, Scott Peterson gets the death penalty. It's because he got a very poor defense.
You would think that Casey Anthony actually got a better defense from her then public attorney. Well, what do they call it? To you at the time, that was Jose Baez. But the defense for Casey, you think was better than the defense for Scott Peterson, right?
Oh my God! I mean, Casey Anthony, that was a tough case. That was a tough case, and she was acquitted. I thought the defense did a terrific job. But the Jodi Arias case was a very tough case to beat the death penalty, and for the reasons I just articulated. I mean, it was very clear this was planned, premeditated, brutally executed. There was an effort to cover it up. She told different stories, and to beat death in that case was a real achievement. And I think the lawyers in Casey Anthony and Jodi Arias all did a remarkable job. I think the lawyers in Scott Peterson were incompetent.
And with respect to the Peterson case, is it true that they were supposed to have something like a qualifying person to go around with them, and the counsel over there didn't have anything like that?
Well, the defense lawyer, Garagos, in my opinion, was not experienced in capital murder defense. I never heard of him ever defending a capital murder case before that. He may have, but I never heard of him doing it, and no one I know had ever heard of him doing it, or at least said they'd heard of him doing it. But what you do in a capital murder case where your client's facing death, it's really two cases in one. You have to prepare to defend what's called the guilt phase of the case, and that's where The jury is deciding whether your client is guilty of murder, and in particular capital murder. And at the same time, you're preparing for the penalty phase of the case, because if your client is convicted of capital murder, or in California they call it murder with special circumstances, you have to be prepared for the penalty phase, which is like a second trial, where you're arguing that death should not be imposed. And typically a good capital defender will prepare for both phases early in the game. You're investigating the case, you're learning the facts, you're learning about the forensics or lack thereof to try and acquit your client of murder or try and acquittal murder, which can bring death. At the same time, you hire experts to go to look at school records, medical records, to investigate someone's upbringing and try and find areas where, you can explain how they had certain, psychological problems or psychiatric problems or problems in the home for which they were not responsible. And you try to create a theme to convince a jury that even though they just convicted your client of capital murder, they should not impose the death penalty. Let him spend the rest of his life in prison, but don't execute the person. In the Scott Peterson case, apparently Garagos either didn't know or didn't bother to hire experts to deal with the penalty phase until after his client was convicted. In fact, he got up in his argument about why his client shouldn't receive the death penalty and said, I didn't prepare for this. I didn't think I'd ever get to this point. And
he said those words in open court?
Words to that effect, which really surprised me. And the other problem with what it did is that when you pick a jury, you're thinking of not only the guilt phase of the case, you're thinking of someone who you hope will be lenient if it gets to a penalty phase. But if you haven't done your preparation for the penalty phase, it's going to affect how you perceive possibly, who should be on the jury and who shouldn't. So the fact that he got up and said, in effect, that I never prepared for the penalty phase, I thought was a horrible admission of incompetence. That's how I interpret it, at least.
Wow, yeah. And his track record in terms of winning high-profile cases is just not there in terms of there's not one case that I can really think of that you say, boom, that's the case, Garagos for. And everybody knows that he was originally with Michael Jackson. And the fact of the matter is, he didn't leave like some reports had said. He was fired by Michael Jackson, right?
Well, I was in Florida with Michael when he terminated Mr. Garagos' services. I was in Florida with him when that happened. I took over, and the rest is history.
Right, and Michael didn't really feel confident. I think you told me Randy and Michael weren't too confident with Garagos in terms of the cameras, the press conferences, some of the things he was saying, right?
Well, they were not happy with his performance, no, and they did not want him to be Michael's lawyer in the criminal case, that's for sure.
Yeah. Okay.
They were bothered by the Winona Ryder defense by Garagos, too. They didn't like that at all.
What exactly what happened in that case when Winona Ryder?
Well, she was taped shoplifting at Saks Fifth Avenue in Beverly Hills, and she hired Mr. Garagos. He defended the case, went to trial, and she was convicted of various felonies, which I think later on were reduced. I think the misdemeanors, but at the time she was convicted of felonies in a shoplifting case, and many people thought it should never have gone to trial.
Interesting, and it's almost embarrassing that he lost that case. Everybody seems to always bring that one up. But from the chat, we got Nance Forster says, can't call in at this time, got a question. He wants to know, ask if he knows that the estate has asked for a summary judgment of dismissal on the Wade Robson case. Do you know anything about that?
No, I don't. I know that the judge threw out on summary judgment. I think it was the case